A major legal development has just sent shockwaves through the national gun control debate. A court has ruled against a magazine ban, declaring it unconstitutional, and now all eyes are turning toward the Supreme Court. This is not just another routine legal dispute. This case could shape the future of firearm regulation across the country, redefine the limits of government power under the Second Amendment, and potentially influence how similar laws are challenged in other states. The ruling is already being described as one of the most significant moments in the post-Bruin legal era, and the possibility of Supreme Court involvement means the stakes have become even higher. At the heart of this story is the court's actual ruling, and that is why this moment is getting so much attention. The law being challenged targeted magazines that hold more than a set number of rounds, often 10, and supporters of the restriction argued that limiting magazine capacity could reduce the severity of violent attacks. But the court did not treat this as a simple policy debate about what lawmakers prefer. Instead, it examined the issue under the modern Second Amendment framework established by the Supreme Court, which requires judges to ask whether the item in question is protected by the Constitution's text and whether the government can point to a historical tradition of similar regulation. That distinction is crucial. The court's decision suggests that magazines owned by large numbers of law-abiding Americans may fall within the scope of constitutionally protected arms, or at least be closely tied to the exercise of that right. In other words, the ruling was not just about whether the law had good intentions. It was about whether the government had the constitutional authority to ban an item that is widely possessed for lawful purposes like self-defense, sport shooting, and training. What makes this especially significant is that the court concluded the government failed to justify the restriction under the required historical standard. That means the ban was not struck down simply because a judge disliked the law, but because the state could not show that this kind of restriction fits within the nation's historical tradition of firearm regulation. For gun rights supporters, that makes the ruling a major constitutional victory. For gun control supporters, it is a warning sign that regulations once defended as reasonable may now face a much tougher legal test. This is exactly why the ruling has become such a major flashpoint in the larger national battle over the future of the Second Amendment. What makes this ruling especially important is that its impact may stretch far beyond the specific law that was challenged. Magazine bans are not isolated policies. They have become one of the most common approaches used by states and local governments trying to impose stricter gun regulations without banning firearms outright. Because of that, when a court rules that one of these bans is unconstitutional, the decision immediately becomes part of a much larger national legal fight. Lawyers, judges, lawmakers, and advocacy groups across the country begin studying the reasoning because it may affect how similar cases are argued and decided elsewhere. This is where the broader significance comes into focus. If a court determines that magazines holding more than a certain number of rounds are commonly owned by law-abiding citizens for lawful purposes, then that finding does not stay neatly confined to one courtroom. It creates a powerful argument that similar bans in other states may also be vulnerable. Even though one ruling does not automatically erase every comparable law nationwide, it can give challengers momentum, provide a legal roadmap, and increase pressure on other courts to confront the same constitutional questions. The timing also matters. In the post-Bruin era, lower courts are under intense scrutiny as they try to apply the Supreme Court's history and tradition test to modern firearms regulations. That means every significant ruling now carries more weight than it once did. A decision like this becomes a signal about where the law may be heading. It can encourage new lawsuits, strengthen existing challenges, and force governments to rethink whether their regulations can survive judicial review. So this is not just one court speaking about one law. It is part of a growing pattern of litigation that could reshape gun policy nationwide. That is why people far outside the state where the case began are paying close attention. The constitutional reasoning here may influence what comes next across the country. The Supreme Court angle is what turns this from an important lower court ruling into a potentially historic national case. Whenever a court strikes down a major firearms restriction, especially one involving a politically charged issue like magazine capacity, the next question is whether a higher court will step in. That possibility becomes even more serious when the case raises unresolved constitutional questions that courts across the country are still answering in different ways. If that split continues to grow, the Supreme Court may feel increasing pressure to provide a definitive answer. This matters because the justices are not just being asked to review one local dispute. They could end up deciding a question with nationwide consequences, whether magazines owned by millions of Americans are protected under the Second Amendment, and whether states can ban them simply by labeling them unusually dangerous or unnecessary. That is the kind of issue that goes well beyond one state statute. It touches the core of how far governments can go in regulating widely owned firearm accessories after the court's earlier Second Amendment decisions. The path to Supreme Court involvement can happen in several ways. A state defending the ban may appeal the decision and seek emergency relief, arguing that the law should remain enforceable while litigation continues. If appellate courts issue conflicting rulings on similar bans, that only increases the likelihood that the justices may eventually grant review. Even if the court does not act immediately, the presence of a major constitutional conflict keeps the case on the national radar. What makes this especially significant is that Supreme Court review could bring much-needed clarity, but it could also raise the stakes dramatically for both sides. A decision from the justices would likely shape future challenges to magazine bans, assault weapon restrictions, and other gun laws. That is why the possibility of Supreme Court action has become such a major part of this story. A big reason this case matters so much is because it shows how the Supreme Court's Bruen decision continues to reshape the entire legal battle over gun laws in America. Before Bruen, many courts used a balancing approach. Judges would often ask whether a gun restriction served an important government interest, such as public safety, and then decide whether the burden on gun rights was acceptable in light of that goal. Under that older framework, many firearm regulations were upheld because courts gave lawmakers substantial room to argue that a restriction might help reduce violence. Bruen changed that approach in a major way. The Supreme Court made clear that courts are no longer supposed to uphold gun laws simply because judges believe the government has a strong policy reason for them. Instead, the analysis now begins with the text of the Second Amendment. If the conduct or item falls within that protection, the government must then show that the regulation is consistent with the nation's historical tradition of firearm regulation. That is a much narrower and more demanding test, and it has forced courts to rethink how modern gun laws are defended. In magazine ban cases, that shift has become especially important. States can no longer rely mainly on arguments about public safety benefits or legislative judgment. They now need to identify historical examples showing that similar restrictions existed and were accepted during the relevant periods of American history. That is often difficult, especially when the law targets items that are now widely owned by law-abiding citizens for lawful purposes. As a result, Bruen has become the central force behind today's most important Second Amendment cases. It is changing not only outcomes, but also the entire structure of the debate. This magazine ban ruling is one more example of how that new constitutional standard is putting enormous pressure on existing firearm regulations and forcing courts to ask very different questions than they did just a few years ago. One reason this case has drawn so much national attention is because the arguments on both sides go directly to the heart of the modern gun debate. Supporters of magazine bans argue that these laws are limited safety measures, not full prohibitions on firearm ownership. Their position is that people remain free to own guns for self-defense, hunting, and other lawful purposes, while the state imposes a restriction on how many rounds can be fired before reloading. From that perspective, the law is presented as a reasonable attempt to reduce casualties in violent incidents by forcing pauses that could create opportunities to escape, intervene, or disrupt an attack. Opponents see the issue very differently. They argue that the Second Amendment does not protect only a stripped-down version of the right to keep and bear arms. In their view, if a type of magazine is commonly owned by law-abiding Americans for lawful purposes, then banning it is not a minor regulation, but a direct burden on constitutionally protected conduct. They also argue that these magazines are standard equipment for many popular firearms, making the restriction more significant than supporters of the ban often acknowledge. The legal conflict becomes even sharper because of the Supreme Court's current framework. Gun control advocates may emphasize public safety, legislative discretion, and the claim that magazine limits are modest and practical. Gun rights advocates respond that modern policy arguments are no longer enough under the Constitution as interpreted by the court. They insist that the government must point to a historical tradition of similar restrictions, not simply argue that the law is beneficial or sensible today. That is why this debate is so intense. Both sides believe they are defending something fundamental. One side sees a preventive safety measure designed to reduce harm. The other sees a constitutional line being crossed. The courts are now being asked to decide which of those views carries the greater legal weight under the Second Amendment. What happens next may be just as important as the ruling itself, because major constitutional cases rarely end with a single decision. Even after a court strikes down a magazine ban, the legal fight usually continues through additional motions, appeals, and possibly emergency requests to higher courts. That means the practical effect of the ruling may not be immediate or final. A state defending the law may ask the court to pause the decision, often called a stay, so the ban can remain in force while the case moves forward. If that request is granted, the law could continue to be enforced even after being ruled unconstitutional at one stage of the litigation. The losing side may also appeal to a higher court, which can either affirm the ruling, reverse it, or send the case back for further review. In a case with major Second Amendment implications, every procedural move matters. A stay request, an appellate ruling, or an emergency application to the Supreme Court can all change the timeline and the real-world impact of the decision. That is why it is important not to treat one dramatic headline as the final word. This also means the case may develop in layers. First comes the lower court ruling. Then comes the question of whether that ruling takes effect. After that, attention shifts to the appellate courts, and eventually the Supreme Court may be asked to intervene. Each stage can shape how broadly the decision matters and how quickly it changes the legal landscape. For people following this issue, the key is to watch the next legal steps carefully. The real question is not only whether the ban was struck down, but whether that victory holds up under further review. If higher courts agree, the ruling could become a lasting precedent. If they do not, the battle continues. That is what makes the next phase of this case so critical in the broader national debate.